You're listening to the Patenting for Inventors podcast, part of the Look Legal Pods from the law firm of Nolan Hyman, the #1 source for your intellectual property, business, and entertainment law needs. Now here's your host, registered patent attorney, Adam Diamond.
Hello and welcome to the Patenting for Inventors podcast. My name is Adam Diamond, a registered patent attorney and partner at the law firm of Nolan Hyman in Los Angeles, California. This is episode 150. What is obvious? A reasonable expectation of success or predictable results? As I've mentioned before, the bane of almost every patent attorney's existence is what obviousness means. Because if something is an obvious modification or improvement over what already exists, then you can't get a patent on it. So the question is, what does obviousness mean? I've talked about obviousness in episodes 3, 47, 48, 49, and 143. So considering that I've talked about it so much, you can tell how important it is. It's so important that I'm dedicating another episode to it because of a case that happened last year that the Supreme Court decided not to hear. What this means is that there was a case at the Federal Circuit that one side lost, and then they petitioned for what's called a writ of certiorari, which means they want the Supreme Court to give an answer. But the Supreme Court doesn't take up most of its cases. In fact, about 97% of the cases, the Supreme Court denies taking up without any discussion whatsoever. So it's not unusual for the Supreme Court to not answer a patent question, even if it's an important one. When that happens, whatever the Federal Circuit held is the law going forward. I've talked about the Federal Circuit before. It's a special court where most of the cases are patent cases, and it's almost like they're the Supreme Court for patents, except when the actual Supreme Court decides to take on a patent case. So what's the question about obviousness that the parties wanted clarity on? The case was Vanda Pharmaceuticals versus Teva Pharmaceuticals. Vanda made a drug called Hetlioz for sleeping disorders, and it sued Teva for patent infringement of that drug. Teva countered and said that Vanda never should have gotten a patent for Hetlioz because, based on what's already out there, Hetlioz was obvious. Now, biotech and drug development is a tricky situation for obviousness because the basic core structures of drugs oftentimes are known because there are classes of drugs that have common chemical structures that treat common diseases, and then you're just adding on a molecule or a group of molecules here and there to make something a little bit different. So pharmaceutical companies are always trying out new variations of drugs, and some work and some don't work. So if you know the basic structure of a class of drug, is modifying that structure to make a new and better drug obviousness, and what's the standard for figuring out obviousness? And that's what this case came down to. There were two choices of tests. One is the reasonable expectation of success, and that's what the Federal Circuit applied. I just want you to sit on that for a little bit, so I'll repeat it. Reasonable expectation of success versus predictable results. Now, under which test will more things be found obvious? Reasonable expectation of success or predictable results? More things will be found obvious under the reasonable expectation of success standard. In biotech, extensive experimentation is required with unpredictable outcomes. They're trying hundreds or thousands or tens of thousands combinations of things that they don't know what's going to work. So oftentimes, there's no predictable result of a specific drug, and there's lots of unpredictable results. Lots of things are based on educated guesses, but not surefire predictions. But there is a reasonable expectation of success, even though it's not a predictable result. So what this means in the real world is that there will be fewer drugs patented under the reasonable expectation of success standard than if we use the standard of predictable results. So in this case, Teva was saying, hey, that new drug you had, based on all the things that were out there and what pharmaceutical drug companies do to develop new drugs, you had a reasonable expectation of success for this new drug. So you shouldn't get a patent on it because it's obvious. And Vanda was saying, that's not the standard. Maybe there's a reasonable expectation of success, but the standard is whether the result was predictable. So we should be able to get a patent on our new drug. The Federal Circuit sided with Teva and said that the standard for biotech is the reasonable expectation of success. So Vanda never should have gotten that patent, and their patent was invalidated. They said it was reasonable that they could expect success in what they were doing to create this new drug. Not that it was predictable, but it was reasonable, and that's what mattered. And of course, Vanda didn't like this. Vanda wanted the Supreme Court to come to their aid, because if the Supreme Court said that the standard should be for obviousness that it's predictable results, then Vanda would have a higher chance that their drug patent was valid. But in April of 2024, the Supreme Court didn't take the case, so the Federal Circuit ruling against Vanda held. So this means, at least for biotech, where there's lots of experimentation going on, the lower standard of obviousness, the reasonable expectation of success, is the test that is used. Now, you can argue about what reasonable means, what expectation means, and what success means, so it doesn't mean every modification of a drug is going to be found invalid, but this is what the attorneys will do in the future, is argue over about what those words mean and how it applies to the facts in the case. But the test standard itself isn't really going to be argued over unless someone else wants to try to take it to the Supreme Court on a different case. This is just one aspect of obviousness analysis, but listen to my other episodes about it if you want to learn more about this topic or any other topic in patent law. Thanks for listening to the Patenting for Inventors podcast, and until next time, I'm Adam Diamond, and keep on inventing.
Thanks for listening to the Patenting for Inventors podcast. If you enjoyed the show, please kindly rate and review on your favorite podcast platform. The contents of this podcast are intended for general informational purposes only. The facts of every legal matter are unique, and the content of this podcast should not be construed as offering legal advice for your specific legal situation. For more information about how we can help with your own legal needs, check out our services at nolanhyman.com. That's NOLANHEIMANN.com. Or call Adam Diamond directly at 424-281-0162. The preceding information may be considered an attorney advertisement and does not establish any attorney-client relationship.